Vocês me ouvem?
Sim.
Peço desculpas, tive um problema com a conexão. Estou usando o computador aqui do meu marido, dá para a gente então iniciar formalmente. Quero mais uma vez agradecer a oportunidade que a professora Mariana oferece a nós. Professora Mariana, uma honra poder, de fato, estar com esse grupo seleto, né, que é às quartas-feiras, às 14 horas, dizer aos nossos queridos amigos convidados, muito orgulho mesmo desse projeto. Hoje, nos bastidores, nosso amigo em comum da professora Gina, que é o professor Adolfo, estava justamente dizendo da importância, Mari, que foi assim, essa mantença do projeto para a internacionalização do programa de pós-graduação. Mesmo em tempos de pandemia, a gente tem se sentido muito próximo, talvez eu diria que muito mais próximo do que se em outros momentos. Então, das coisas boas que a gente pode tirar desse momento tão difícil, tem sido essas superações no nosso dia a dia, nesses nossos encontros, ainda que virtuais. O programa de pós-graduação da Unimar, ele se realmente inovou nesse sentido. Nós estamos não fazendo algo simplesmente de saindo do offline para o online, nós estamos de fato fazendo a diferença, não apenas na vida da nossa comunidade, mas dos nossos alunos, dos nossos egressos, dos nossos professores, enfim. Por isso, mais uma vez, eu quero agradecer essa oportunidade. Eu fiquei longe, professora Mariana, faz alguns dias que acho que eu faltei as duas últimas quartas-feiras, e aí eu já confesso que eu já estava com saudade desse nosso programa tão importante, que é sobre os diálogos, sobre o desenvolvimento em empresa e sociedade. Queria cumprimentar o nosso palestrante, nossos convidados, né? Professor Harney, Dr. Harney, um prazer imenso tê-lo em nossa universidade, sinta-se de fato acolhido nessa instituição. Professor Dr. Marcelo, a gente já nos encontrou em outras oportunidades aqui nesses nossos encontros do PPGD, então, muito a honra poder novamente tê-lo aqui conosco. Querida professora doutora Gina, muito obrigada pela parceria com a Unifor. Nós temos tentado realmente estreitar esses relacionamentos interinstitucionais, acreditamos na potência dessas parcerias. Então, realmente, aqui, em nome da direção, da reitoria da universidade, quero colocar a Universidade de Marília à disposição dessas parcerias com a Unifor. Temos admiração pelo trabalho de vocês. Não sei se Mariana comentou nos bastidores, mas o nosso reitor, né, meu pai, ele foi o fundador da universidade, muito próximo com a história da Unifor. Então, muito legal tê-la aqui nesse momento ímpar para a nossa instituição. E a nossa querida Sinara, nossa professora Sinara, que também estava com saudade mesmo, sua e da Mariana, porque eu andei faltando aqui, estou quase tendo uma advertência aqui dos nossos encontros às quartas-feiras. Queria dizer que a Universidade de Marília, ela realmente tem feito um enfrentamento com todos os desafios que nós estamos encontrando, mas superando. Dizer do orgulho dos nossos professores, dos nossos acadêmicos, dos nossos pós-graduandos. Eles realmente têm feito a diferença na comunidade. Nós temos um hospital beneficente ao lado do campus universitário, que ele é referência ao combate da Covid-19. Então, realmente, nós temos uma equipe que está, de fato, na linha de frente. Não paramos as pesquisas, mantivemos todas as nossas pesquisas institucionais, com fomento, com parceria. Então, diante dessa realidade, hoje a gente já consegue imaginar um momento pós-pandemia, ainda que num momento tão difícil que ainda nós vivemos. Nesse momento a gente já vê a educação como sendo pauta aí, né, dos nossos principais governos, tanto o governo municipal, estadual, federal, e para nós que trabalhamos, que acreditamos numa educação, que de fato a gente só enxerga uma forma de realmente modificar e inovar é através da educação. Então, Mariana, parabéns mais uma vez por esse trabalho. Achei, professora Gina, que iríamos ter férias do projeto de Mariana de internacionalização, mas ela não deu férias sem férias, sem vacaciones, nada. Aqui não tem, aqui tem apenas muito trabalho. Então, muito obrigada pela oportunidade e eu coloco realmente a Universidade de Marília à disposição de todos nós. Obrigada.
Obrigada, Fernanda, pelas suas palavras, sempre lindas palavras, como a pessoa que você é. É um orgulho muito grande para mim fazer parte dessa universidade, desse projeto. O professor Jonathan Vita hoje não pôde nos acompanhar também, por alguns outros compromissos que estavam previamente agendados, mas eu também faço questão de registrar aqui o meu parabéns a ele pelo projeto, pela forma como ele idealizou todo esse enfrentamento, né, do PPGD nos tempos da pandemia. Realmente, uma série de oportunidades foram criadas e nós agora estamos nos sentindo mais próximos e com um trabalho cada vez mais potente. E, Fernanda, não adianta você falar que eu não dou férias, porque se tem uma pessoa que é pior que eu aí no Brasil, nesses PPGDs, é a professora Gina, viu? Ela é famosa na praça. Então, se falar que eu não tiro férias para ela, ela também é pior. Se multiplica por 10 e aí é a professora Gina. E nós já estamos aí com vários projetos, vários planos, várias ideias para a integração aí dos nossos PPGDs. A professora Gina já me convidou também para fazer um curso agora, lá em novembro, na universidade dela, e vários projetos se concretizarão. Não preciso nem falar sobre o professor Marcelo, né? Parceria incrível, ele também um dos grandes incentivadores desse projeto, junto com a professora Maria Helena Diniz. Essa apresentação com a Universidade de Regensburg hoje é fantástica e a gente tem que agradecer ao professor Marcelo também por todo o apoio que tem dado ao nosso programa. E professor Marcelo também breve em Fortaleza, porque também já estamos fazendo... O bom desse projeto, Fernanda, é que as pessoas vão passando por aqui, se integrando com a Unimar, e a gente vai construindo uma grande rede de internacionalização. E aí eu acho que é vantajoso para todo mundo, para os alunos, para os professores estrangeiros, para os professores do Brasil que estão participando. É uma experiência profissional e pessoal muito rica. Então, é um privilégio realmente poder participar disso. Eu vou pedir licença agora para falar em inglês, para a gente começar a trazer mais para perto aqui o nosso palestrante de hoje, que é uma sumidade na Alemanha, no mundo, e é uma honra tê-lo, né, conosco hoje. Hi, everybody. Hello. Good afternoon. For those who don't know me yet, my name is Mariana Santiago. I am professor of the master's degree and the doctorate in law at the University of Marília in São Paulo. I hope you all are well and safe in these difficult times that we are living. It's not so easy, these pandemic times. We start now our event titled Dialogues on Development, Company and Society. It's an event organized by University of Marília, but it's now completely open to all the law community. So welcome everybody. We have students for all over Brazil with us today. I'm so glad and so grateful for this. Thank you so much. It's a pleasure today to have with us her Professor Dr. Rainer Arnold. He's full professor at Universität Regensburg in Germany. He has published many books and articles, in fact, more than 400. It's incredible. And he also has received many prizes, including doctorates honoris causa. He has accepted several visiting professorships in many countries like France, Russia, Chile, Italy, etc. It's a great honor for us to welcome you, Professor Arnold. Welcome. Today, his lecture will be about rule of law. And besides that, we also have with us today Professor Dr. Marcelo Figueiredo from Catholic University of São Paulo. He is one of the most important professors of constitutional law in Brazil, and he will present the Brazilian perspective of the team. And I would like to mention also the presence of Professor Dr. Gina Pompeu. She is the coordinator of the Master's and Doctorate in Law at the University of Fortaleza, and she will discuss the topic with us in a dialogue. So finally, I wish everyone a great experience. Professor Arnold, feel free to start your lecture. My German is terrible, but now I will try to say some words for you. Es ist uns eine große Freude, Sie bei uns an der Universität Marília begrüßen zu dürfen. Vielen Dank.
Oh, vielen Dank, perfect. Dear Mrs. Dean, dear Professor Mariana, dear and friend Professor Marcelo Figueiredo, dear colleagues and dear students. So I speak in English today because unfortunately Portuguese is not yet so familiar to me. I speak Spanish, but not yet understanding so well Portuguese, but nevertheless, I will learn it. This is an inspiration for me today. So I try to speak slowly, and then we will have a discussion, as we said, so that I can answer maybe in Spanish. And so with some help, I can understand maybe your questions in Portuguese. So my subject is a very important subject in constitutional law in Germany, but not only in Germany. I think in all democratic states. It is the subject of rule of law, or as we say in German, Rechtsstaat. This is what you, I think, say, Estado de Direito. And this rule of law is the foundation of contemporary constitutionalism. It is a universal concept developed within the state, but then enlarged and transferred to international and supranational organizations and introduced in important aspects, even in international law. Rule of law is a key concept of the national constitutions in Europe and also in other parts of the world. So what is, and this is the first question, what is rule of law? The basic concept says that the state, a public power, has to act in conformity with law. It is not allowed to act against law, and it is not, the state is not allowed to act, let's say by force, by violence, or by a mere political, arbitrary decision. It is really law, and we must have the question of what is law? Well, legitimation of public power, as I say, is only given if its exercise is conform with legislation and with the Constitution. Legality means conformity of state action with legislation, what is made by parliament, by the representatives of the people in parliament. Normally, this is legislation, but the common consens, as we say, maybe the social contract in constitutional terms, this is a constitution. And both, it is necessary that the actions of a state are conform to legislation as well as to the Constitution. the basic element of today's rule of law is the primacy of the Constitution. So the first question was, what is rule of law? Rule of law, I can say, is the activity of the public power in accordance to legislation and the Constitution, roughly defined. Well, rule of law of today is value-oriented. It is not only a formal concept. A formal concept would say what public power makes is legitimate if it is conform only to what is written in legislation. No, we have today not only the formal rule of law concept, but the so-called substantive rule of law concept. Substantive means that rule of law is an instrument, is a method to realize or to contribute to realize justice. So the Constitution contains values, and this is very important, of course, because these values are an integral part and maybe the most important part of rule of law. Rule of law is seen from the values, I say, anthropocentric. Anthropos means human being, a person in ancient Greek. It centers, it focuses on man, on human being. Rule of law recognizes human being as the center of law and makes manifest that the ultimate finality of law, and in particular of constitutional law, is to protect and promote the individual. The Constitution is therefore necessarily based on the recognition of human dignity as a supreme value and of its twin principle, the principle of freedom. Rule of law is value-oriented. It is based on human dignity and on the principle of freedom of the individual. And it is inseparably linked also with democracy as an essential element of freedom of the individuals. The individuals which constitute the people, the freedom to co-determine politics. This means the decisions about their lives, their destiny through elections and through the daily participation in political discussion. Well, the very nucleus of, I will repeat this in summarizing, the very nucleus of rule of law is that power, public power, state power, and even on the level of supranational law, as we have in Germany, we always think in European Union, also on this level, and on the level of international organizations, as far as they are in direct contact with individuals. So this means that public power has to act in accordance to the will of the people, and the will of the people is expressed by legislation, which is made by the representatives of the people in the parliament, or in direct democracies, let's say by referendum. And this is very important, but because this is the new approach of rule of law, and according to the Constitution. And this is a classic dictum, as a French Conseil Constitutionnel, the Constitutional Council, has said in 1985, legislation, what is made in Parliament, is the expression of the general will of the people only if it is conformed to the Constitution. So the old concept of Rousseau, that legislation is what Parliament says, what the majority of Parliament says. This has been actualized, this has been updated in the doctrine and in practice today, updated as that legislation expresses the will, the general will, the will of the people only if it is conform to the Constitution. This means rule of law of today is essentially based on constitutionality. In history, during the 19th century and before, even in Germany, but not only in Germany, but here with a certain, let's say, significance, the concept of rule of law and the term rule of law has developed. But it was a formal concept. This has meant, well, it was a first victory of Parliament, of maybe to some extent democracy over the monarch, of the king. The king was the executive, but then the formal concept of rule of law says or said that the executive had to obey what Parliament says. So this was the orientation towards the legislation. But today it is a step even forward. It is the primacy of the Constitution, which is recognized, and it is the obedience to law, to legislation, in conformity with the Constitution. And a second point, let me repeat, is the value orientation. This is very important, that the value part of a Constitution, which is the most important part of the contemporary Constitution, the fundamental rights, which are based on the idea of human dignity. These values are integral part of rule of law of today. And then it is logic consequent that democracy is not only making laws by majority, by political majority, it is also realizing values. Democracy means that the individual participates in the destiny, in the determination of its own, her own destiny. And this cooperation, co-determination of political, the political process, this is also a part of freedom, and it is inseparably linked to freedom and to dignity. The German Federal Constitutional Court has several times underlined that democracy is very close to human dignity. And so we can say that rule of law is a functional unit. Today it unites dignity, freedom, democracy. And these values are expressed explicitly or implicitly by a constitution. And so the primacy of the Constitution, this is the very core element, the very core aspect of rule of law of today. Well, rule of law is a general concept, but has a great spectrum of aspects, of specifications, which are commonly recognized. Well, I would distinguish three aspects of rule of law elements which concern law itself, rule of law. And so we must ask, what is law? Which qualities has law? They must be preserved by rule of law. First, well, this is a formal element. This is a substantive element. And I would say this is an institutional element. So formal element, this is results from the formal qualities of law. The law must be clear and understandable. Yes, and this is security of law means also that this law is closely determined in penal law, in criminal law. This is a very important matter, that the legislation which penalizes certain facts, that they are very clear and determined in advance. So this clearness and the quality to be sufficiently and determined, this is very important as a formal element of rule of law. Second is the substantive element. I would say that is the stability of law. Security of law, but this also means that the individual can rely upon law. This is the confidence in law, which is a protection of the legally acquired position of an individual. This cannot be, well, this is very important, the stability of law. So one of these problems is, that retroactivity of legislation of law is very problematic. Normally, this is not accepted by rule of law. Well, this means if law has regulated a certain issue, and this issue is completed, is closed, then the legislator cannot interfere, cannot roll up again this matter, this issue. For example, a tax assessment is completed. Well, and legislation cannot retroactively roll it up and maybe demand a higher tax for a tax period which is already in the past. So we have retroactivity is one of the major elements. The prohibition of real retroactivity is the main, one of the main elements of security of law and of confidence of law. So legal position which has been acquired under a certain legal regime cannot be changed in an essential way, so that the confidence in this position, the confidence in the function of law is disappointed. Well, okay, this is the second element. The third element, I think, is an institutional element, and this is that law is made secure not only by its formulation, but by judicial review and judicial control. So the justice, the existence of an independent justice, which comprehensively controls and revises the power, the state power activities, is indispensable for rule of law. It is really one of the most important and indispensable aspect of rule of law. So judiciary, the existence of an effective judiciary, the independence of judiciary, and the competence of the judiciary to control the state powers without, in principle, without exception. This is a rule of law requirement. And here we can say that the modern development, contemporary constitutionalism, is the true constitutionalism, is characterized also by constitutional justice. Constitutional justice means this is the control, the revision of the review of legislation and of political actions. This is made by either specific constitutional courts or by ordinary courts, Supreme Courts, as you have it in Brazil, but we in Germany and in Europe, not in all the countries, but in most countries, there are specific constitutional tribunals, constitutional courts. We always call this a model of Hans Kelsen, who was an Austrian and established the first separate constitutional court in 1920, a court which had for the first time the competence to review and to annul legislation. So this is, as it is said by some people, and I would agree, constitutional justice and the review of politics, particularly of legislation by constitutional courts, is a perfection of rule of law. Well, this is a large system, so we can say that in many countries, well, the constitutional justice system is developing, the individual is involved. In Germany, we have the recurso de amparo, what we call, means the individual complaint. Even an individual can address to a constitutional court in order to realize rule of law. If this person is individually concerned by legislation in one of his or her fundamental rights, it goes and it has a right to go directly to the constitutional court. And this individual complaint, this is very effective. It is, maybe we have, in Germany, we have 6,000 individual complaints to the constitutional court per year. Well, more than 90% are not accepted, but those complaints which are accepted are of highest importance for the development of constitutional law. All our constitutional concepts have been developed on the basis of such individual complaints. But we have the contrary, the review of legislation as an expression of rule of law in many countries, initiated either by courts, by tribunals, which address the Constitutional Court for having reviewed a piece of legislation they have to apply, or even by state institutions. This is a very common system today. So we can say that constitutional justice is going on and developing. And well, this is maybe we can say today, the European model, the Kelsen model, and you have more the Supreme Court model, the American model. This is very well known that in 1803, even in the very early times, the United States Supreme Court has annulled a piece of legislation for non-conformity with the US Constitution in Marbury versus Madison. And this was a very significant event in United States, which with impact also on legal thinking in Europe, not on legal practice, but on legal thinking. So we can say in a certain summary that the existence of an independent judiciary, the existence of an efficient control of public power activities by judges, and in particular the control and review of the constitutionality of legislation and of political actions, is a very big, great progress in rule of law. And it is, I think, justified to speak of a certain perfection of rule of law. Well, these are the various elements of rule of law which are connected with law itself, with the concept of law. But there is also are elements of rule of law which are related to the relation between law and freedom. The ultimate finality of law is to serve the freedom, let's say, and progress, promotion, protection and promotion of human being, of the individual. This is, as it was said even by Latin authors, this is the ultimate finality is hominum causa. Jus hominum causa means law exists for the benefit of human being, of the individual. This is what I call an anthropocentric approach. Anthropos, human being, is in the center of law, and is the ultimate finality of law, and also of constitutional law. And therefore, as I already mentioned, and I want to repeat it because it seems to be important, that in the center of law is human dignity. And well, this can be expressed by constitutional law, or it is inherent, even implicitly. And you have it also in your constitution, as we have it as value number 1, as Article 1, paragraph 1 of our constitution is human dignity. And this human dignity is the basis for the principle of freedom. The principle of freedom means that the individual is protected against all the dangers of this freedom, either dangers which exist or which will appear in the future. So I speak of the substantive efficiency of the principle of freedom. And the principle of freedom means not only what is written explicitly in the Constitution is applicable for freedom, is protecting freedom. No, freedom, principle of freedom is comprehensive, is total. It is expressed or not. This does not matter. If it is not expressed, it exists. And the judges, in particular constitutional judges, have to discover it, not to invent it. They cannot make constitutional law, of course, but they can discover, they can reveal disclose what is unwritten. And the protection fully is written and unwritten. Well, this is a substantive efficiency of the principle of freedom. And there is also a functional efficiency of freedom. And this is that fundamental rights, the freedom of the individual, dignity is absolute, but freedom is shareable, has to be shared, has to be distributed within the other members of the society, of course. And so it must be shared, it must be restricted. And yes, but restriction, and this belongs to the functional efficiency of freedom, the restriction must be made by legislation, by law, by parliament, not by the executive alone. And it must be, and this is important, and this is an essential element of rule of law, it must be conformed to the principle of proportionality. Proportionalidade, this is also in Brazilian law, but is universal. Perhaps our constitutional jurisprudence has developed it in the early, even before, in the end of the 1940s, this principle was named by the constitutional jurisprudence of the Bavarian Constitutional Court, and then has been transformed also to the federal constitutional courts in very early decisions. And now it is, if you look at a decision of constitutional court, you find with yes, you cannot miss to see proportionality. Proportionality is a magic instrument. It is it indicates the borderline between freedom and restriction of freedom, because freedom is the principle, and exception of freedom must be legitimated, and proportionality can say where this borderline goes on. Of course, this is in the hands of the judges, and proportionality is a very flexible, is a very efficient instrument, and is let's say it is a legitimate instrument, but it is exposed to the interpretation by the judges. And indeed, today, in the situation of the pandemic, also in Germany, the principle of proportionality has the most important role, most important part in the constitutional considerations of the courts, which deal with restrictions caused by the pandemic. So the proportionality, I think in all the countries, they are based on three elements. So appropriate, there is restriction, the interference with freedom must be able, apt, appropriate to contribute to a realization of the legitimate aim of this restriction. Yes, but the second aspect is important. Only necessary interferences are allowed. If there is a milder, if there is a less interventive instrument or restriction for realizing or contributing to realize the legitimate aim, then this milder instrument must be taken. This is the principle of minimum of intervention. And the third one is the proportionality in a narrow sense, which means there is a ponderation, a weighing up between, on the one hand, the public interest, and on the other hand, the individual interest, which is expressed by fundamental rights. And the question is this measure tolerable by the concerned individual? If not, then the measure cannot be carried out. And so I think that proportionality is one of the most important instruments of modern constitutionalism, and it is based on the recognition of the principle of freedom, but it is also based on the conviction, clearness that freedom is not total. Freedom must be shared with the community. And as our Federal Constitutional Court says, well, the idea of human being, which is the idea on the basis of our constitution, of our basic law, is not the idea of an isolated individual, but of an individual which is integrated into a community. And dignity is absolute, but the freedom which is connected with dignity is limited. And it must be limited, of course, in a proportional way, in a way which can be accepted, which can be regarded as legitimate in view of this principle of freedom. Well, let me make a short summary. I said rule of law is not a formal concept, it is a substantive concept today. It is not a national concept only, it is a universal concept. In all liberal democracies, there is rule of law is existent, if it's written in the constitution or not. We have many constitutions, more older ones, they do not write it in there, but they are based on rule of law, this is clear. Rule of law is essentially characterized by constitutionality. The constitution as the common consent on the common legal basis of a community, let's say of a state. This has primacy, and legislation must be conformed to the constitution. And it is value-oriented. What is important that the rule of law and law itself, it's always connected with the individual, with, I would say, with human being, and because this is axiomatic in my view, the central point of constitutional law, the human being. And well, and we have several aspects which are also rather universal, because they are logic consequences of rule of law. This is formality. A formal aspect is clearness, determinateness of law. This is stable, the stability of law, which means the individual can have confidence in an existing law. There is no possibility for a real retroactivity of law. This is a stability, and it must be institutionally secured by an independent and efficient judiciary, and today more and more also by a constitutional justice. And then we have a relation, the important relation, which is already expressed in what I said before, between individual and rule of law. And this is that the freedom, the principle of freedom, is guaranteed by proportionality. And proportionality is an element which is characteristic for rule of law, and which is also characteristic for the fundamental rights protection. And here we see the coincidence and the combination, or let's say the mutual contact between fundamental rights, freedom, and rule of law. And here this highly important instrument of proportionality is indicating this connection, this intrinsic connection of freedom of values and rule of law. Thank you so much, and I hope I was understandable, more or less, and good. And now I'm ready for questions, and first to hear listen to my dear colleague, Marcelo.
Thank you so much, Professor Arnold. Your lecture was perfect, brilliant. And now we will have a chance to hear Professor Marcelo Figueiredo about the Brazilian reality, about this so important and current theme.
Thank you. Bom, em primeiro lugar, podemos falar em português só para os agradecimentos. Então, eu quero cumprimentar a nossa reitora, doutora Fernanda, dizer que é uma honra poder novamente estar aqui na Unimar, a Mariana, minha querida colega, pelo convite, a professora Mariana Diniz também, que nos assiste, é uma honra poder contar com a sua assistência, a professora Gina, quem eu tive o prazer de conhecer hoje, e a Sinara, que já tivemos contato na outra vez também da live, e o meu querido amigo professor Arnold. O professor Arnold, além de um grande jurista, conhecido internacionalmente, eu tive a honra de participar com o professor Arnold em vários congressos, eventos. Ele é um grande organizador, sobretudo de professores do mundo todo se reúnem na Alemanha, num encontro em Regensburg, cada 2 anos, enfim, e este encontro tem sido realizado em outros estados, né? Tivemos a honra de estar em vários desses estados, na Moldóvia, na França, na Itália, enfim, em países da Europa do Leste, e tive, inclusive, a oportunidade de assistir uma entrega do título de doutor honoris causa do professor Arnold num desses países. Foi uma cerimônia muito emocionante. Pois bem, eu preparei aqui 4 folhas, 3 a 4 folhas de papel, para falar um pouquinho sobre o Rule of Law, o Estado de Direito, e eu vou procurar fazer uma síntese, porque o professor Arnold já enfim, já esmiuçou a matéria muito bem. A minha preocupação é mais, talvez, trazer um pouquinho mais o conceito para a realidade latino-americana. Pois bem, então vou falar em inglês, porque é o convencionado hoje aqui. We just heard a brilliant lecture by Professor Reinhard Arnold on the rule of law. Now I must say a few words and make some reflections on the rule of law in Latin America. Let's get to it. In the 20th century, after the post-war period, the rule of law was established as one of the happiest formulas in Western political and legal philosophy. As Bobbio rightly stated in his work, The Age of Rights, he positioned himself in favor of rule of law, or regardless of the rule of law as institutes whose purpose is to guarantee subjective rights. It would be naive to seek a univocal and ideological neutral semantic definition of rule of law. Professor Arnold just told us all the concepts and elements of this important standard, international standard, national standard. I should say an international standard today. Today, we can say that the concept of rule of law comes from the different historic experience, essentially four experience: the German experience, that of the English rule of law, second, the important variant of the American rule of law, and the French état de droit. It's also a very important element of this substantial concept that Professor Arnold already told us. It's not a case to deepening or recovering this concept that Professor Arnold just told us. It's more, in more analytical terms, it can be said that the rule of law is a juridical institutional figure that results from a secular evolutionary process that lead to the affirmation within the structures of the modern European state of two fundamental principles: that the diffusion of power and that of the differentiation of power. The diffusion principle tends to limits with explicit links the state power to expand the scope of individual freedoms, just like Professor Arnold said and explained us. I would like just to remark, it's not a crisis of the rule of law, but really it's the illiberals, democracies that we have, some in Latin America, some in the world, that exactly conspire against the principle of the rule of law. We can say that on this issue, the magnitude of the phenomenon is the consequence not only of the despotic or totalitarian character of many regimes, but also of arbitrary decisions by international subjects endowed with great political, economic, or military power, a power that the process of globalization have made overwhelming and uncontrollable, and against which it's the shadow of global terrorism. The war, the death penalty, the torture, the prison maltreatment, the genocide, the poverty, epidemics, international trade rules, foreign debt that bleeds the poorest countries, neo-slavery, exploitation of minors and women, and the racist oppression of marginalized peoples, from Palestine to Kurds, Tibetans, Indo-Americans, Gypsies, African and Australian Aborigines, and the devastation of the natural environment are under accusation. The degradation of the Latin American rule of law can be explained by internal and external causes, according to the lesson of Professor Elias Diaz. For the author, what characterizes the rule of law is rule of law itself, division of powers, administration oversight, and fundamental rights for all. It's very important that Professor Arnold also remarks that it's the judiciary review and the role of the judiciary in the protection of rule of law, of the rights, freedoms, etc. So I should say that in this context, the judiciary branch appears as the protagonist for several reasons. Analytical constitutions, in our case, the great opening of the judicial review, also in our case, and all over Latin America, and the political inability of Parliament to face the great moral issues of society, throwing them at the doors of the courts, thus appearing the negative judicial activism. Administration supervisions exists, but often the private interests of powerful companies dominates the parliament and endorse behavior harmful to the state and society, undermining the effective fight against corruption. Fundamental rights are covered by the various constitutions in Latin America. However, huge population groups in Latin America do not have formal employment and are condemned to social marginalization outside the network of citizenship rights and third-generation social rights. Social violence is a constant, and therefore fundamental rights do not reach a large part of the population. Finally, we can say that the non-governability of democracies is a phenomenon related to the deficit in deliberation and civil participation. The persistent institutional weakness of democracies and civic weakness of democracies, and strongly linked to their unrepresentative character, which turns public issues into private matters and triggers a process of apathy and impotence. In any case, the rule of law seeks alternatives and antidotes to the voluntarism of power and as an instrument capable of taming a sovereign and sometimes arbitrary will that constitutes, in any case, the excess of order in countries full of social exclusion. This is the small words to, let's say, summarize our problems concerning the rule of law in Latin America, in our region. Thank you very much, Professor Arnold. Thank you very much, my dear friends. And we are here to answer any question that you might have. Thank you very much.
Thank you, Professor Marcelo Figueiredo. You have lots of fans in my university. My students are really crazy for you. You deserve all the status you have in Brazil in constitutional professors, between constitutional professors. And it's so beautiful to hear the humanity and sensitivity of your speech. Congratulations. And now I would like to hear our dear friend, Gina Pompeu.
Olá, Mariana. Boa tarde a todos. I would like to thank University of Marília, Unimar, to be part of this event on behalf of Professor Fernanda Mesquita and Mariana Santiago. It is a pleasure to hear lectures by Professor Heiner Arnold and Marcelo Figueiredo. And as we see, constitutional law professors so far from Brazilian reality. We are still, as Ferdinand Lassalle said, constitution as a simple piece of paper, far from Conrad Hess' wishes. As we just hear what Professor Marcelo Figueiredo said, unfortunately, it's still difficult to talk about stability, freedom, liberty, human rights, when you have 50 million people under poverty line in Brazil. So anyway, the community, we have discussed a lot about the role of judiciary. Many argue that judiciary is an agent of democracy. Others praise judicial activism and judicialization of politics. As a professor of constitutional law and an analyst of the state's legislative power, I'm afraid of too much interference of the courts in every dimension of our lives. The work describes an imaginary judge with superhuman skills, called Hercules. Hercules as a model of perfect judge in deciding hard cases. In Brazil, we call judiciary hypertrophy. Professor Marcelo, I don't know how to say hipertrofia do judiciário. I don't know even if it doesn't exist in Europe, but here we are very afraid about it. In this sense, I pose 3 questions for the speakers. Professor Heiner Arnold, the work insisted in the coherence of principle as the main element of interpretation to seek the solution of the specific case from a coherent framework of political axiology. Robert Alexi, on the other hand, emphasizes not the narrative coherence of principle, but the case-by-case analysis of the specialities and urgencies of each case, which would justify the application of one principle harder than the other. Which, in your judgment, is the best narrative of law? Is the best narrative in law? To privilege the coherence of principles or the urgence of the specific legal cases? Are any of these elements protagonists in the legal tradition remedies of the German Constitutional Court? This is the first question. The second question I would like to hear you is about what you said about the anthropocentric approach. Mariana asked me last week to study a lot about nature law. So I would like to ask you is it possible to change the European Charter in the way to change the anthropocentric approach to one ecocentric approach? Can we think about nature law as a supreme value? Because as I could a chance to hear from your speech, we're still thinking a lot about human dignity as a supreme value. Last week, we had a chance to hear one professor, Dr. Muntaito, trying to say that the way we should think was putting nature values, nature law at the first place, because she said that there is no human dignity without respecting the nature. So I would like to hear you. And then, if it's possible, I would like to ask Professor Marcelo Figueiredo, knowing the concept of democracy as the decision of major, respecting and observing the individual rights of minorities, we have in mind that judicial activism works as an impressive task to restrain majority decision and to avoid the so-called tyranny of majority through the ideally impatient entity. In contrast, it's questionable the legitimate and democratic factor of the expansion of jurisdiction, observing the principle of separation of powers. Knowing that neo-constitutionalism and the expansion of judiciary raised it as an alternative against the emergency of the totalitarianism in the social states. What's your point of view about the democracy versus human rights in the context of judicial activism? And what you considers that works more in this scenario? This question comes from one of our students. We have a study group here in Brazil, in Fortaleza, and as you are well known, Professor Marcelo, as one of the greatest constitutional law study, this student would like to know what you think about this contrasense or this opposition between democracy versus human rights in the context of the judicial activism. So, Mariana, I know that I have not much time, but I would like really to, I think that we have a lot to talk with Professor Arnold. I had a chance to read a lot of your papers. Mariana sent me, she didn't send me, but she sent me your name, and you have really a brilliant career. I could see all your work about the European Charter, and I'm amazed with your work. So for me, it's a pleasure to be here, but I have also more doubts than certitude about the courts, the instability we have in Brazil. We are really far from constitutional law and our reality. Every day as professor is more difficult to talk about that because Brazilian reality is very far from what we would like to have it. Maybe it's easier to talk in older countries, in the old world, but here, this text has been a very hard work for the Brazilian professor. So thank you very much. And Mariana, please, I would like to have the answers. If you understood what I said, if you don't, I can repeat, please.
Thank you, Professor Gina, for your considerations and questions. I think we can begin for Professor Arnold, but I think I should make an explanation about these questions of rights of nature. In my university, Professor Arnold, we have an important partnership with a project of United Nations. It's called Harmony with Nature. And we studied in this project, and Professor Gina is with us on this. We study the possibility of giving rights to nature to change this question about a subject of law. And you should know we have something like this in Constitution of Ecuador and Bolivia, Colombia. So this is a different perspective. It's a kind of a biocentric perspective. And we have some events in the university about this theme. And Professor Gina has been with us in these events, and we'll have some others in 2 weeks. In 2 weeks, we will have with us Professor Cormac Kuliman from University of Cape Town, and he is an important professor in this line, in this topic. So this is probably the reason that Professor Gina is asking you about this perspective, not so anthropocentric. I know that Germany has a different perspective. It's not so similar with Brazilian experience, because you have a lot of anthropocentric, but something like not so strong as Brazilian experience. But let's hear you about the questions of Professor Gina, please.
Well, shall I speak in Spanish, or how is it? Yo puedo hablar en...
Hable, por favor.
Sí, sí.
Puedes hablar en español, no, es perfecto para mis estudiantes.
Ajá, sí, comprenden más. Well, muchas gracias por las preguntas muy interesantes, muy importantes, profesora Gina. Yo comienzo por la primera pregunta, creo, la segunda pregunta, que es el antropocentrismo, ¿qué es la naturaleza? ¿Qué papel tiene la naturaleza? Son dos aspectos, creo. Este biocentrismo es que la pregunta de saber si hay derechos subjetivos o objetivos de la naturaleza para conservar la naturaleza es pero es diferente, creo que, de la pregunta que ha planteado profesora Gina. Antropocentrismo. Yo creo que el núcleo del derecho constitucional es veramente el hombre, el antropocentrismo. ¿Por qué? Yo soy un poquito influenciado por digamos, el enfoque del Tribunal Constitucional Federal Alemán, que es muy optimista yo creo que es un hecho, es algo, la existencia del hombre como en su naturaleza, naturalmente, en su calidad que se basa en su naturaleza, que es axiomático, axiomático y es el valor supremo, pero reconocido por el derecho. Y el derecho es, ¿qué es el derecho? La norma, un instrumento para la organización de una comunidad, de una pluralidad, de multitud de hombres. Y ¿qué es? Yo creo que el convencimiento de hoy en día y es el que se concentra todo, se reconoce más que anteriormente la importancia o importancia, digamos, exclusiva o del hombre. Naturalmente, la biocentrismo, claramente hay discusión en Alemania, si el biocentrismo es la protección del medio ambiente, algo para el hombre o algo para sí mismo. Eso, claramente, hay dos, creo, los dos son existentes, coexistentes, porque la existencia de la naturaleza es para el hombre. Y la situación biológica o en total tiene siempre un impacto en el hombre. Por eso es relacionado con el destino del hombre. Si se aprecia tanto el hombre, debe apreciar también la naturaleza. Y por eso hay una comunicación. No sé si se puede realmente separar estrictamente esos dos caminos, esos dos enfoques. Derecho natural o derecho de la naturaleza, natural law, no se habla directamente en Alemania de eso, pero es la existencia, la naturaleza del hombre que es el marco para el derecho. Y el derecho no constituye el hombre. no constituye su dignidad es existente en la realidad ideológica, pero realidad también, realidad real, sustancial. Y eso debe ser respetado por el derecho, y en particular el derecho constitucional. Y, pero es algo que existía siempre, pero no fue reconocida suficientemente en los tiempos cuando que han practicado la servitud, etc. No, es más y más reconocido. Yo creo con una emancipación del hombre, que es un proceso multifuncional y internacional también, no nacional, es económico, técnico, ¿sí? La comunicación, todo eso tiene desventajas también, pero mucho contribuye al progreso del hombre.
Obrigada.
Hello? Eso, hello? No.
It's everything okay. It's working. We can hear you.
Continue? Yes.
Yes, don't worry.
Yeah. Okay. Sí, bien comprendido la pregunta, la segunda pregunta. Yo diría en resumen que es la naturaleza, naturalmente, del hombre, reconocido la existencia del hombre en su naturaleza psíquica, física, intelectual, social y todo eso, que conduce al reconocimiento de la dignidad humana como categoría de derecho constitucional. Por eso no diría que es un retraso, un regreso a la época del natural law, porque el derecho debe corresponder a lo que existe. Existe factualmente, realmente, la naturaleza. Y por eso no creo que hay una contradicción de esto. La primera pregunta, no sé, naturalmente son preguntas de gran impacto, la interpretación ya. Yo estoy, yo diría que es justamente esta punta de salida, este punto de salida, también el hombre en su posición jurídica constitucional, que es el punto de salida para la interpretación. Y interpretación son principios, reglas, principios, claro, esta distinción de Dworkin, claro, yo creo que hay principios no escritos que, claro, por ahí es un sistema, es una construcción, un edificio constitucional. Edificio tiene un fundamento, tiene pilares, tiene principios como los ligamentos, conexiones, y por eso pero principios que son interconectados. Yo creo que Estado de Derecho funciona como una unidad funcional, porque tiene su comienzo o su fundamento en la dignidad, y la dignidad presupone necesariamente la libertad. No hay dignidad sin libertad, no hay libertad sin dignidad. Y por eso son interconectados inseparablemente. Y la democracia es una subcategoría de la libertad, porque es la libertad política, la codeterminación. Por eso la democracia es la realización no de una mayoría, no de números, solamente es de valores. Y sí, por eso hay reglas, pero reglas son concretizaciones, concretizaciones de principios, o son reglas autónomos que son que hay en la ley fundamental hay muchas reglas. Hay también principios importantes, escritos y no escritos. Principio de proporcionalidad es un principio no escrito constitucional. El tribunal siempre dice que es un principio no escrito, claro, y es derivado de principios más de la libertad. No es escrita la libertad, es el artículo 2, apartado 1, que es la libertad en general, pero no necesariamente es escrito así. Sí, y caso por caso, no diría que es, la interpretación requiere, es muy, de manera muy resumida que yo formulo la respuesta, es hay esta doctrina de la caso por caso, que es no creo que se debe basarse en un sistema que requiere la existencia de principios, de reglas, de una coherencia. El Tribunal Federal dice que no dice nada sobre su metodología de interpretación, pero dice que la Constitución es una unidad coherente y sí, y los derechos fundamentales es un orden objetivo de valores. Sí, yo creo que... Ahora, unos puntos, no sé si he respuesto de manera suficiente, pero...
Está perfecto, profesor.
Pero es muy interesante y me interesa este biocentro, este proyecto de las Naciones Unidas sobre la naturaleza, que es...
Sí, yo voy a enviar más informaciones para que
muy
puedas
interesante.
comprenderme un poco mejor.
Ya.
Es un proyecto que tiene unos 10 años. Está junto a la Directoría de los Asuntos Económicos y Sociales de las Naciones Unidas. Y ha tenido una gran repercusión en Brasil porque la situación ambiental en Brasil es muy grave. Hay una crisis. Es probable que conozca esto porque es tan grande que hay una proporción internacional. Muchos accidentes y crímenes ambientales.
Sí, Mariana, se me permite, não apenas em Brasil, mas na Europa e por todos os cantos.
Sí.
It's not only in Brazil, professor, but in all Europe, because a lot of countries as France, England, and whatever, they want always to teach Brazil how you must be. But I asked if it's possible to change the European Charter in this way, to change anthropocentric to an ecocentric approach, because in Brazil we have not much articles. We have just one article that think like that, the Article 22.5. But this question I asked for you is the same question as I asked myself. I have no answer. As you, I think always about an anthropocentric way. But now we have been argue, is it possible to have this anthropocentric way and not respect nature law? And is not nature law more important than our dignity, our human dignity? So I have no answer for that. I'm always thinking about this because I think that we need to change and think in a different way, because we have no human dignity without nature laws as a stakeholder. Nature is a main stakeholder. So I think that law must think in a different way. We have no, we don't have enough law to protect nature. So I was just thinking, as I saw a lot of papers, your papers, working and thinking about anthropocentric, I was just trying to think together if it's possible to include ecocentric way. So, but I like a lot your answer. I was very good, your reflection. And we are thinking together, Professor. We have no answers. We have just questions at this moment.
Yes, no question, no answer, and we have to think together about it. And there is a movement, an international movement in United Nations about creating a universal declaration of rights of nature. And it began in Bolivia, and now it's international. It's an international movement. I think we should participate of this because we have the Amazon, so it's a great responsibility for Brazil.
Yes, and the second question was because we received here in our university Professor Robert Alex twice. He has been here with us, and so we always study at one side at working and the other side Robert Alexi. And the questions about the sopesamento do direito. Each case we must evaluate and see. That's why I would like to hear. We study a lot of Gustav Harbrucken, Robert Alexi, and Dworkin on the other hand, Hart and Dworkin. So, and now Heiner Arnold. I will give all your text to our students. I was very happy to hear your papers, and now we're going to start to get Heiner Arnold, Dworkin, Robert Alexi, and Gustav Harbrucken. Thank you very much for all your explanation.
Thank you, Professor Gina. Now let's hear Professor Marcelo Figueiredo about his considerations.
Well, I don't know if I speak Portuguese, Spanish.
You can choose what you want.
Talvez começar por português, mais fácil. A pergunta que a professora Gina acabou de fazer é uma pergunta difícil, porque diz respeito digamos, aos limites do ativismo, tá? O que vem a ser o ativismo. O que ocorre, vamos dividir a resposta em duas. Eu diria que nós temos um necessário ativismo a partir das constituições analíticas que nós temos na América Latina. Então, isso responde, em parte, uma parte do problema. Ou seja, por que os juízes, inclusive os juízes constitucionais, muitas vezes praticam um ativismo exagerado? Esta é a pergunta. Por quê? Primeiro, talvez porque as constituições tenham muitos direitos e esses direitos sejam muito detalhados, muito minuciosos. Primeira, talvez dê essa abertura ao Poder Judiciário. Segundo, o Brasil, no meu modo de ver, tem um controle de constitucionalidade extremamente amplo, né? Se nós compararmos o controle brasileiro com outros controles, como o americano, o espanhol, o alemão, o italiano, nós vamos ver que nós temos um controle muito aberto, com muitas possibilidades de atores. Então, isto, vamos dizer assim, generaliza, vamos dizer, amplia muito os direitos e tem um lado positivo e um lado negativo. Qual é o lado negativo? Eu diria que é o bloqueio da criatividade social. Os parlamentos, que já não são muito operosos, deixam ainda mais de trabalhar. Por quê? artificializam essas questões e jogam no colo do Poder Judiciário. Isto ocorre muitíssimo, nós vemos isso quando um partido é derrotado no parlamento, ele ajuiza uma ação de inconstitucionalidade abstrata no Supremo Tribunal Federal para ver o que o Supremo pensa sobre qualquer questão que seja minimamente constitucional. Então, isso é uma realidade. Eu diria que o lado negativo da judicialização excessiva, e nós vemos isso em vários direitos, nos direitos sociais, no fornecimento de medicamentos pelo Poder Judiciário, pela excessiva judicialização das políticas públicas, o que também não é algo comum no mundo. Não é comum que o Poder Judiciário judicialize nas democracias liberais as políticas públicas. Isto é uma realidade particularmente brasileira e um pouquinho latino-americana, eu diria, mas particularmente brasileira. Não há essa excessiva judicialização das políticas públicas. E o lado negativo, portanto, voltando à linha de raciocínio, é exatamente esse, ou seja, os grandes problemas morais, os grandes problemas políticos devem ser resolvidos pelo parlamento. Não devem ser resolvidos pelo Poder Judiciário. E, infelizmente, no Brasil, ultimamente, tem havido uma excessiva judicialização de todo e qualquer fato da vida política. Eu brinco, às vezes, com os alunos, dizendo, olha, daqui a pouco alguém vai entrar com uma ação judicial, para o Ministério Público, talvez, para dizer que ele não concorda com a mão de direção dessa rua. Ela não deve descer, ela tem que subir, né? Ou se um gato foi parar numa árvore e ele vai dizer que aquilo é maltrato aos animais. Então, veja, é um lado irônico, mas retrata um pouco isso, quer dizer, não é possível que toda e qualquer política pública seja judicializada, né? Isso significa o empobrecimento da democracia, o empobrecimento da representatividade dos políticos e o empobrecimento da política, tal aristotelicamente falando. De modo que eu não sou, de modo algum, um inimigo do judiciário. Sempre escrevi meus trabalhos a favor das ações judiciais de avanço social, como mandado de injunção, etc., etc. Mas é preciso considerar que nós estamos nos excedendo. Nós, eu digo, sobretudo Supremo Tribunal Federal. E eu não falo apenas desse momento agora, que é um momento difícil, posições antagônicas, crises e discussões, etc. Eu falo do ponto de vista teórico, quer dizer, não estou preocupado com figura A, ou B ou C, né? De modo que é o que eu posso dizer nesse momento sobre isso. Acho que a judicialização brasileira é uma jabuticaba, quer dizer, só o Brasil tem, né? Não sei se o professor Arnold sabe o que é uma jabuticaba, mas eu posso levar uma jabuticaba para a Alemanha, quem sabe. It's a fruit, it's a Brazilian fruit that only has here. It's a very tasty fruit, black. It's like a berry, but it's round and very tasty. We have liquor of jabuticaba and very nice. So the next time I take you a bottle.
Okay.
Things that we only have in Brazil. Thank you, Professor Marcelo, for your considerations about these problems that we have in Brazil, in judiciary now, and it's truly serious. And we are all in Brazil very worried about it. It's not so recent, but now it becomes more dangerous, maybe. I think, yo pienso que estamos en el final. Yo ya no sé qué hablo, en qué lengua, en qué idioma hablo, estoy un poco confusa. Vamos a hablar un poco en español. Pienso que estamos en el final de este evento. Me gustaría agradecer a los profesores invitados de hoy, profesor Arnold, profesor Marcelo Figueiredo, profesora Gina Pompeu, que es una felicidad para mí tenerla, una grande amiga y representa el Nordeste. Yo soy de Bahía, soy de Nordeste, entonces para mí es una alegría muy grande tenerla con nosotros. Yo vivo en São Paulo, pero soy de Bahía, entonces es muy importante para mí decirlo. Entonces estoy muy agradecida, muy honrada con la presencia de ustedes hoy, hablando para mis estudiantes. Yo pienso que esta internacionalización es fundamental para el crecimiento de estos estudiantes del área de Derecho. Son estudiantes de doctorado, maestría, entonces es preciso que tengan nuevos paradigmas porque necesitan trabajar con originalidad. Entonces, saber qué se pasa en otros países, en otras visiones, con otros profesores que estudian otras versiones, otros autores, es muy importante para el crecimiento de los estudiantes. Tenemos, profesor Arnold, estudiantes en mi universidad, porque São Paulo es un país central en Brasil y atraen estudiantes de todas las partes. Entonces, en mi universidad tenemos alumnos desde Acre hasta el sur, Paraná, Santa Catarina, Rio Grande do Sul, el centro, todo. Entonces, es muy rica el pueblo, los estudiantes. Es muy importante para nosotros agregar las personas de todo el país. Entonces, crea que hoy su ponencia fue vista, asistida por estudiantes de todo el Brasil. Es un honor tener un profesor como usted en nuestra universidad. Espero tenerlo en presencia en futuro, recibirlo en Brasil, en nuestra universidad, en Fortaleza, en Católica, Universidad Católica de São Paulo, también Universidad Marília, es tu casa. Espero que nos quedemos en contacto en Brasil cuando vengas o en Alemania también, porque estamos siempre en Alemania también. Es un honor, una felicidad. Me gustaría oírlo en sus últimas palabras para mis estudiantes de despedida. ¿Podrías hablar un poco? You can say some words, end words to my students.
Ja, fue un gran placer veramente que he tenido la posibilidad de hablar con las estudiantes. No he visto visualmente los estudiantes. Me recuerdo mis conferencias en Sao Paulo, en la Universidad Católica con Marcelo, en otras universidades. Yo ya estoy a menudo en América Latina, en Chile, en Perú y en Brasil. Espero que puedo digamos, repetir y estar en contacto con Internet es posible. Y me interesa mucho las preguntas de los estudiantes y la reacción, y por eso yo estoy pensando en el desarrollo de un sistema de contacto por Internet sobre cuestiones interesantes del derecho constitucional, de desarrollos. No, me gustaría naturalmente estar en contacto también en el marco de este sistema con las estudiantes de la universidad. Muchísimas gracias por la atención y la paciencia de escucharme. Muchísimas gracias, realmente era un
Gracias, profesor.
evento muy agradable, muy inspirante, inspiración intelectual. Aprendido mucho hoy, sí, ¿no? Es muy exitoso también para mí.
Sí, nosotros vamos a continuar esta discusión acerca de los derechos de la naturaleza en
Sí,
futuro.
muy interesante, muy interesante.
Professor Marcelo, suas últimas palavras para meus estudantes.
Olha, bom, eu queria, em primeiro lugar, agradecer a você muito, a sua universidade, a oportunidade por estar junto com o professor Arnold, que é um grande amigo, conhecer a professora Gina pela primeira vez e seus alunos, também é um grande prazer, espero poder estar em Fortaleza. Faz tempo que eu não vou a Fortaleza, viu? Mas também depois da pandemia a gente não vai a lugar nenhum. Mas, enfim, quem sabe, quem sabe. Logo, logo, se Deus quiser, temos uma vacina aí para a gente poder viajar e tomar uma cerveja lá com o Rainer em Munique.
E uma caipirinha em Fortaleza.
Ou também uma água de coco com uísque em Fortaleza.
Em Fortaleza,
mas
gostei.
Também é muito bom.
Gostei dos planos todos.
Exato. Os planos estão ótimos, pós-pandemia. Né? Mas, enfim, eu queria uma palavra aos alunos, dizer que é importante que vocês sempre persistam na pesquisa, é muito importante que vocês pesquisem. Eu acho que essa é a lição que nós todos podemos dar. A única diferença entre nós e vocês são alguns anos a menos, né? Alguns poucos anos, uns outros mais, mas, enfim, alguns anos. Então, é importante que haja pesquisa. Eu vi algumas estudantes aqui comentando, falando, então, enfim, uma palavra de alento aos estudantes que vale a pena a gente estudar, não é? Sempre a gente aprende um pouquinho mais todo dia. Nunca, isso é todo dia, é um pouquinho, né? De modo que é esse o recado que eu queria dar, enfim, e dizer a todos que permaneçam saudáveis e espero que com muita saúde.
Obrigada, professor Marcelo. O senhor é sempre convidado aqui nesse projeto. Já esperamos tê-lo novamente aqui nos debates.
Obrigado.
Professora Gina, suas últimas palavras de estímulo aos meus estudantes.
A professora Mariana Santiago trouxe hoje para os alunos e para a academia uma reflexão importantíssima sobre the Rule of Law, o império da lei. No Brasil, nós questionamos muito até que ponto o judiciário hoje se acha como agente democrático, até que ponto a gente tem a estabilidade da lei dos julgamentos ou até que ponto a gente acaba cedendo para a pessoalização do poder. Enfim, não temos muitas respostas, mas temos muitas perguntas e é como o professor Reinhardt falou, estamos instigados a continuarmos a pesquisa e os estudos e a defesa do bom direito, porque para mim nada há de mais importante do que a liberdade, a legalidade e a velha Constituição francesa, professor Reinhardt, liberté, égalité e fraternité. E isso a gente tem que ter uma estabilidade longe das vaidades, longe da busca do poder pelo poder e daquilo que é simplesmente decisão diária para ter mais poder. Enfim, muito obrigada, professora Mariana, por acompanhar esse evento de hoje. Gostei muito, tive a oportunidade de ler os textos do professor Reinhardt. Tenho outros livros ainda para ler, não consegui ler todos. Professor Marcelo Figueiredo eu já conhecia, já adotava alguns livros dele. E vai ser um prazer, professores, recebê-lo em Fortaleza. Professor Reinhardt, Lisbon, Fortaleza, just 6 hours. So you must begin by here, and then you go into São Paulo. We're going together to São Paulo, okay? You get it by Fortaleza. And then
I'm often in Lisbon, in the State University. I make always an intensive course there every year. And yes, so I know from my friends from Lisbon that it's 6 hours only.
6 hours straight. And Mariana, very good. Thank you very much.
Você é sempre convidada. Aqui também espero revê-la em breve, aqui nos debates, professora Gina. E vou me despedindo em português dos meus alunos. Espero vocês na semana que vem para mais um evento. Nós vamos ter uma presença muito especial. O presidente da Associação Euro-Americana de Direitos Humanos, diretamente da República Dominicana, na próxima semana, vai falar um pouco para a gente sobre assuntos de direitos humanos e também sobre essa importante associação de direitos humanos. Eu vejo vocês na próxima semana. Muito obrigada pela presença de todos e até mais.
Muito obrigado, muito obrigado. Adiós, adiós.